Good afternoon, everyone. Thank you for attending today's webinar on Proposition 64 presented by Gina Rakanova. This is our fourth installment in a six-part series. We hope that you join us for the next portion of our webinar, which will be on January 18th. A schedule of our full Proposition 64 webinar series is available on the last slide of today's presentation. A couple housekeeping items. First, all of your telephone lines are muted. If you would like to ask a question, you should have a Q&A box at the top of your screen. Please type your question in this box. Gina will be answering questions as they come in, but please keep in mind that we have a lot of folks registered for today. So if Gina does not get to your question, she will reach out via after the webinar by email or phone. We're also offering CLE credit for this webinar. If you check the box on our registration form to receive credit, a CLE form will be emailed to you early next week. We also will email the slides to all attendees later this week. Now to introduce our speaker, Gina Rakanova. Gina Rakanova is a principal here at Myers-Nave and chair of the Labor and Employment Practice Group, where she serves public and private clients with nearly 20 years of experience in negotiations, counseling, litigation, arbitration, and training. She is well known for her ability to communicate and create an atmosphere of trust in successful, high-profile situations. That is all for administrative matters. I will now hand it over to Gina.
Thank you very much. Good afternoon, everyone, and Happy New Year. I'm going to have to ask everyone's indulgence if I start sounding hoarse or sniffly. I've got what seems to be a very widespread post-holiday cold, so forgive me if I'm a little hoarse. So obviously there's lots of interest in this topic, and just want to reiterate that I welcome questions. It keeps everything, I think, more interesting for all of us if you are, sharing your concerns and asking questions throughout the presentation, and I will do my best to answer them as they come in. So let's start with what we're going to cover in this webinar today. We are going to talk about what, if anything, Prop 64 changed. We're going to go through some potential approaches for employers. The good news is that Prop 64 leaves employers lots of options. It expressly puts very few, if any, limits on your ability to set policy in this area. So we're going to talk about approaches that I call just say no, the don't ask, don't tell approach, treating medical marijuana like prescription opiates, which is something that some of you might have been doing all along under the Compassionate Use Act. Or taking a really hard line stance, which you are still entitled to do, which is prohibiting the use of marijuana on or off duty. And then we're going to spend a little time at the end talking about how to communicate with employees on this topic, just as many of you in HR and the legal side are interested about this. I'm sure you know that, your employees and your various agencies and companies have questions as well. And there's a big question around whether you should raise the topic at all or whether you should just take questions as they come in. So we're going to spend a little time discussing that. Okay, so let's start by backing up and kind of looking at what the status quo was a month ago, or 2 months ago. Before Prop 64, the main components of the law in this area were the California Health and Safety Code, the Compassionate Use Act, which, as you're probably aware, has been around for 20 years now, and a 2008 case from the California Supreme Court called Rossi, RagingWire Telecommunications, which really added quite a bit of clarity to what employers' responsibilities are with respect to medical marijuana, and it continues to be relevant. So, I guess the good news here is that in a lot of ways, the Compassionate Use Act presented tougher legal questions than Prop 64 likely will, because with the Compassionate Use Act, you had to handle all these issues relating to disability, reasonable accommodation, disability discrimination, etc. Those issues have all largely been settled. So, let's talk about each of these in turn. California Health and Safety Code explicitly provides that employers do not have to allow the use of marijuana in the workplace or during work hours. And that has not changed under Prop 64. And, of course, there are lots of good reasons why you wouldn't want to allow the use of marijuana in the workplace or during working hours. So your right to prohibit that is protected by the Health and Safety Code. Then you have this case, Ross v. RagingWire. For those of you who would like to read the case, it is a pretty good read. The site is 42 Cal 4th 920, a 2008 case by the California Supreme Court. And in that case, the court looked at a claim by an individual with a disability who had a recommendation for medical marijuana, and he was denied employment based on a drug test, a pre-employment drug test. He had been forthcoming. He presented his medical marijuana recommendation right up front. And the company's board met and said, no, we're going to deny him employment. And the court concluded that that was perfectly legal, that the Compassionate Use Act did not require employers to accommodate the use of medical marijuana. And the way the court looked at it was to say, in passing the Compassionate Use Act, California didn't wholesale legalize marijuana, and in fact it was and still is illegal under federal law. What it did was remove certain criminal penalties for certain types of uses. But the public policy underlying that statute, and as articulated in that statute, did not require accommodation of its use, and in fact protected the right of an employer to fire or decline to hire an employee for marijuana use, including medical marijuana use. So we had a pretty clear picture of the legal landscape. Before Prop 64, you had this very clear statutory language in the Health and Safety Code. You had the Rossi RagingWire decision, which further clarified that, and therefore public agencies and private employers were free to prohibit any marijuana use on or off duty. They had the option to, take other approaches to it, but no requirement that they do so. So how does Prop 64 affect this analysis? Well, it doesn't, so we can all go home now, right? Easy peasy. Well, maybe not quite so easy peasy, but on its face, Prop 64 explicitly preserves the right of employers to maintain a drug-free workplace. And I'm going to read you a little selection from the statute itself. It says, nothing in this section shall be construed or interpreted to amend, repeal, affect, restrict, or preempt, inter alia, the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace, or require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace, or affect the ability of employers to have policies prohibiting the use of marijuana by employees and prospective employees, or prevent employers from complying with state or federal law. So what Prop 64 did essentially was to codify the state Supreme Court's decision in Ross v. RagingWire. So we've got this solid legal language still. But there are some subtleties here that I think it's important for us to look at as well. Obviously, the law outside the employment realm has changed. So adults may legally now possess, transport, grow, and share small amounts of marijuana for recreational purposes. And next year, there are going to be dispensaries where they can engage in commerce related to marijuana. So that is a big change. And what's happening alongside that is a big change in public attitude. So according to a fairly recent study, 1.4 million Californians, 5% of the adults in this state, even before Prop 64, said that at some point in the last 20 years, they had used medical marijuana. And let's not forget that Prop 64 itself passed by a pretty wide margin, something around 54%, if I'm remembering correctly. So the attitudes towards marijuana use are evolving, I think it's fair to say. And as you look at your workforce and as you, have people retire out and younger people join your workforce, you may see a big shift in attitudes, and you may experience, particularly at the bargaining table, far more resistance than you're used to policies prohibiting off-duty use. Drug testing policies were not required by federal law, and the like. So it's important to start thinking now, even though the law on its face doesn't require you to do anything. You can continue legally, and I want to be very clear about that, you can continue to do whatever you were doing before. You have free reign. So now we're really talking about what might be a good idea as far as looking down the road, planning ahead for changes and considering perhaps some alternatives. So here's where things get a little hazy, pun intended. What about off-duty conduct? This may be something that's now is going to come up in a way that is different from before. So we know you can still legally prohibit the use of marijuana on or off duty by your employees, and that's pretty clear in this language of the statute. And you can still test, and we're going to talk about testing in a minute, you can still drug test as you did before. But for those of you who have employees who have just cause rights, either because they are public employees or because they are represented by a union under a collective bargaining agreement that provides for just cause, you're going to have to think about how to establish a nexus between off-duty marijuana use, if your policies prohibit that, and the job. Now, that was easier to do when the conduct was illegal because you had an argument. How far it went probably depended on the substance of the job, but you have this argument, they're engaging in illegal conduct. That is not protected. We no longer now have that argument available to us as we arbitrate these cases. And so we'll need to be creative about how we get that idea across. The other problem that we have with our drug testing regime is that there are pretty significant limits, technological limits, to the tests that we have for marijuana. It is very difficult, not impossible, but pretty difficult to establish impairment on the job. So if you are saying, okay, maybe he smoked marijuana off duty, but he was still high as a kite when he came to work, simply doing a drug test is not going to enable you to prove that. You will need other evidence. It looked like we had a question, but it's not coming up. Okay. All right. So let's talk a little bit about the drug testing and its limitations. Now, obviously, Prop 64, state law, does not affect in any way, shape, or form the Federal Department of Transportation regulations. So for those of you who have DOT-covered employees, you proceed as before. Not a darn thing has changed, nor can you change that. You continue as you were previously. For everybody else, you can still administer pre-employment, post-accident, and reasonable suspicion testing for your non-DOT employees. Now, your ability to drug test employees, as you probably all know, is not an unlimited right, okay? There is a constitutional right of privacy. This is a bargainable topic, and as you may know, random testing is considered unconstitutional, and there also may be local ordinances that affect this analysis, such as the one in San Francisco. So if you're doing testing, you have to be mindful of those limitations. But here are some additional limitations. THC, which is the active ingredient in marijuana, and I love this part because I get to get all sciencey, which is something that I rarely get to do. THC is metabolized very differently from most other drugs. It doesn't just go through your bloodstream. It gets stored in fatty tissue. And it's the longer or the more habitual a user somebody is of marijuana, the longer it tends to stick around in their bodies. So different types of tests have different sensitivities, and unfortunately the most commonly used form of testing, the urine test, is probably the worst at being able to tell you whether somebody is actually impaired at the time of the test. So for the first problem with the urine test is that it doesn't actually measure the psychoactive component of THC. It measures a metabolite that is not the impairing part of the molecule, and the metabolite it measures is detectable for days or sometimes even months after the person most recently used the drug. So it tells you a big fat load of nothing, basically, other than at some point in the not too distant past, somebody used marijuana. Blood tests are a little more accurate, but again, let's not forget this constitutional right of privacy we have, and the more invasive a test is, the higher the bar is for showing justification for using it. You may, if you can get that bargained into your collective bargaining agreements, that may be helpful, but keep in mind, though, with the blood tests, even with the blood tests, which are a little more accurate, regular users may still show THC metabolite in a blood test in their system for a week after they've used the drug, long after they are no longer impaired. Okay, looks like we've got a couple of questions. Okay, do safety-sensitive position classifications allow the nexus you referred to regarding off-duty use? Great question, and here is, you're really getting to the heart of the matter, right? You have a better argument, if it is a safety-sensitive position, you have a better argument that the possibility of being impaired has a closer nexus, right? So maybe the testing doesn't tell us exactly whether the person was impaired. We don't have that information, and I'm going to talk a minute about another way to kind of get at this. But yes, in general, of course, it's going to be easier to establish a nexus if there's a safety-sensitive position. Keep in mind, of course, that the courts are more predictable than arbitrators, so we have to work hard at it and maybe employ some very creative strategies if we are going to succeed in arbitrations of separations based on marijuana use. Okay. And what basis would we have to request a blood test when a urine test is part of your normal process? Thank you. That is also a great question. If your normal process is a urine test, if your employees are represented, then you'd have to bargain that. You'd have to bargain a blood test and be prepared to expect a lot of resistance on that. Here's another option, though, that you should consider. Saliva tests, which are considered one of the least invasive ways to test. And strangely enough, they are actually a little bit more accurate than urine tests. And from what I've read, that is an area that is improving faster than the other tests. So there are new saliva tests being developed that can narrow that temporal window. They can tell you with a little more accuracy when the person ingested the drug. And it may be easier to bargain a saliva test than a blood test. Okay. Right. So, moving back to our slides here. So, what do we do in this instance? So this moves me to one of my favorite topics, and it's one that isn't necessarily limited to the area of drug use. It has to do with addressing behavior rather than speculating on the underlying cause of that behavior. And this applies equally well to mental health issues, right? So a little anecdote. I had a client call me one time and in kind of a panic and say, we have an employee who is running up and down the halls, shouting and throwing pencils at people. I said, well, that's alarming. What do you want to do? We want to send her for a fitness for duty. Really? And what do you think the fitness for duty is going to tell you? Well, it's obviously she's got some mental health issue. Okay, so you find she's got some mental health issue, and then what do you do about it? Wouldn't it be better to address the conduct? She's throwing pencils. That is not okay. And it kind of doesn't matter why she's throwing pencils. If she's throwing pencils, you can discipline her for that. And being mentally ill or high on some substance is not an excuse. You don't get to throw pencils no matter what is going on with you. So similarly, in this context, if what you're worried about is impairment on the job, and add to that this issue of the limited usefulness of testing for THC metabolites and how, whether that can measure impairment, you're always going to be better off basing your discipline, if any, on the conduct manifested on the job. Obviously, this is easier to do with non-safety sensitive positions, and in an ideal world, you'll have both, right? If you can drug test and you have objective documented evidence of impairment, that's your best case scenario. What I see happen, though, is sometimes people overlook the objective evidence of impairment and just rely on drug testing, and that is a mistake. So if you have someone who is appearing uncoordinated, again, if they are not able to do the job, it doesn't really matter why. You may end up having to start an interactive process, depending on what they tell you when you say, is there anything I need to know about this? But you can start the disciplinary process on the basis of conduct or an observed inability to perform the job well and safely. Sorry, I got a question here about OSHA, and I have to just give you a disclaimer. I am not an OSHA expert, but I am more than happy to take a look at your question. I think it's a very good one, and get back to you on it. So there's a question about blanket post-accident drug testing and an OSHA determination. I do recall seeing something about that. So I will take that up and get back to you directly. Thanks for the question. Okay. So let's talk now about some potential approaches, big picture policy approaches for employers. And again, you don't have to change anything. But if you want to think ahead and you want to think about different ways of looking at employee marijuana use now that it's legal, here are some ideas. One is you can just say no. You can say, sorry, it's not okay for you to use marijuana on or off duty. And, the more safety sensitive the position is, the more tolerable this is going to be. It's legal to do it. What you're going to run up against is whether your employees, whether you're going to be able to attract and retain employees if you do this, depending on where you are, and, of course, your employee unions if you have them. The approach that's sort of the default approach for non-public safety and non-safety sensitive positions is what I describe as a don't ask, don't tell, right? So as long as an employee is, oops, no, what happened to my slide? Sorry, technical difficulty. Messed that up. Sorry about that. As long as someone is doing his or her job, meeting the employer's standards, performing well, and is not, smoking marijuana at their desk or using it in any kind of obvious way or dealing it out of their desk drawer, as long as your standards are met, who cares? this is not an applicable approach if you've got somebody driving city vehicles or operating heavy equipment, but for your average desk jockey, this might be just fine. That you're not going to test, and as long as they're doing their job, everything's fine. And as I mentioned earlier, unless you are actively subjecting people to drug testing, this is really what you have. That's kind of the default. Okay, so we have another question here, really good question. Hypothetical. An employer has a no marijuana policy. An employee claims that they need to use it medically. Could they bring an ADA claim stating that the employer is not allowing reasonable accommodations? Great question. This is exactly what Rossi v. RagingWire was about. In that case, the California Supreme Court addressed that question head on. It was a FEHA reasonable accommodation claim, and the court said, no, you do not have to accommodate use of marijuana, because all the Compassionate Use Act did, and similarly all that Prop 64 does, is remove criminal penalties from certain activities involving the use, possession, and distribution of marijuana. And it explicitly says an employer does not have to accommodate it. That doesn't mean you can't accommodate it if you want to. Of course, if you're going to go down that road, keep in mind the needs of your other employees as well as public safety. You really don't want to have somebody who is impaired, engaging in any activity that could put themselves or other people in danger. You can also consider, you get a lot of flexibility in the reasonable accommodation process. So if you're accommodating somebody, what you're accommodating is not their treatment so much as their underlying disability. And if there is a way to accommodate them that doesn't involve allowing them to be impaired at work, then that may be worth discussing. Okay, thank you for that question. Okay, so again, the landscape as far as drug testing, and there's an important footnote here. What you can do with respect to drug testing is limited to DOT regulations. If you've got employees covered by those, you got to follow them. You can do pre-employment screening if it's applied to everyone, subject to local restrictions. You can do reasonable suspicion testing, keeping in mind that that is a subject of bargaining. The post-accident testing, I'm going to put a pin in that because yes, there is this little OSHA wrinkle in there. You can do legitimate job-related medical screening. Again, got to be really cautious, and I would not do that without consulting counsel. And then random screening programs for safety-sensitive positions are permissible, but again, the level of safety sensitivity has to be commensurate with the degree of privacy invasion. Another possibility, and I have it as a sort of 3A and 3B. The first part of this is something that a lot of employers have already been doing because, again, medical marijuana has been around for 20 years. And there are employers who have decided to treat it pretty much like a prescription opiate. So it's a substance that is prescribed, recommended, that an employee uses to treat a condition that can affect the performance of the job. Prescription opiates are kind of the same way. And so employers have put in place a variety of policies around that. For example, having a policy saying if you are taking any prescription medication that may affect your judgment or your ability to safely do your job, you must disclose that fact so that we can engage in the interactive process and figure out whether we can accommodate that, or we may have to move you temporarily or put you on leave. That is an approach that could work equally well for somebody who uses marijuana medically. And if you're going to have a policy like that, these are some elements that you probably want to have in place. So you require disclosure of any circumstance, including a medication that would jeopardize their ability to safely perform their job. You have to draw a line where the use of medical marijuana would impact other employees, especially in a safety sense, but also, you can take into consideration inconvenience and the burden of job duties. There's a big difference between ingesting marijuana and smoking it. If no smoking laws apply to this too, and you should not make an exception for marijuana if you don't allow tobacco smoke. Your policy has to provide that you can't put anybody in danger, and that employees who are impaired, regardless of the substance, obviously should not be operating heavy equipment or motor vehicles. And the last thing is that if you do make allowance for employees who are using medical marijuana or any other medication for that matter, you do not have to compromise quality. You do not have to accept substandard work. And that's a general rule of disability accommodation. Now, caution here. Obviously, this approach is not going to work with DOT-covered positions, and is probably not going to be the best path for other true safety-sensitive or public protection positions. But depending on the nature of the work, the culture of the workplace, and the standards of your community, that's particularly applicable for public employers. This could be a very useful approach. Now, here's part B. What about recreational marijuana? Well, you treat that like alcohol, because that is another impairing substance that is legal for adults to use. So if you permit alcohol use in your workplace, well, you could think about permitting it. Again, not the smoking, but if you have a party where you're allowing that, you could. You don't have to, and it's probably a little much for most employers right now. But the same way you wouldn't permit somebody to be impaired by alcohol at work, you don't permit them to be impaired by marijuana at work. And as I said before, if you're going to have to prove that, you have to rely on evidence in addition to a drug test, because that's only going to tell you part of the story. Okay. So now let's talk about, before we get to our Q&A, let's talk a little bit about communicating with employees. And I didn't do any slides on this because it's kind of hard to put down any hard and fast rules. There's a debate about whether employers should affirmatively raise this topic with their employees now that Prop 64 has passed. And I think this is an area that you have to play by ear. On the one hand, you could open up quite a can of worms if you suddenly put out some communication and employees didn't really have this on their radar to begin with. So, one option is just to say nothing and assume that your current policies continue and assume that everybody else knows that. Another option is to put out a very, sort of mildly worded general communication saying, Prop 64 has been in the news. People may have questions about it. Please be aware that the employer's policies are not changing in this regard. If you have any questions, please see so-and-so in HR. Another option, of course, is to, do a little asking around and take the temperature. And the size of your workplace and the diversity of your workplace, your workforce is going to make a difference here as well. But you may be able to get a sense by asking a few people whether there really are questions or people are afraid to come forward and ask them, and that could be a factor in deciding whether to communicate with them about this. So, my goodness, we got through this really quickly. If there are any more questions, I would be happy to try to tackle those. And if not, I guess we can wrap up. Thank you for participating this afternoon. I appreciate it. Have a great day. Oh, wait, we got a couple questions. All right. Can you ban employees from cultivating? Very interesting. You know, I'm going to say that provided you can establish a nexus between cultivating and their job, then you can. But gosh, establishing that nexus could be hard. Certainly, law enforcement, you can probably establish that nexus because it's still illegal under federal law. But I think it's more of a reach. The further away you get from this impairment on the job concept, the harder it's going to be to establish that nexus. So I think that's where the rubber hits the road on that one. How are you defining drug-free workplace? You know, there are definitions of a drug-free workplace all over the place, and for certain federal and state contractors, there are statutory or regulatory definitions that apply. But outside of those requirements, you can kind of define it however you want. You can, as I said, prohibit the use of alcohol or any other intoxicating or impairing substance on duty. You can, prohibit the use of any substance that is illegal under federal or state law on or off duty. You can define that in a way that makes sense to you and your workforce and your community. Okay. Can public employers perform pre-employment testing on applicants for all positions? So, again, the general starting place is that employees do have a privacy right, and so you have to measure the degree of invasion against the utility of it. But in general, yes, you can. And pre-employment testing, the bonus of that is that is not, you do not have to bargain over that. So in general, yes, you can. Okay. Here's another, these questions are fantastic. If an agency decides to hire someone who tested positive for marijuana and later is involved in an accident, how does this affect the agency? Obviously, the agency will be liable for the accident, but testing positive for marijuana, will it compound the outcome? It could. But again, this is where it is helpful to draw on analogous situations. So if you test, if the drug involved were not marijuana but prescription opiates, and somebody had tested positive for opiates and they weren't disciplined for it, yeah, that could affect your liability. It's a little fuzzier, as I said, because of the testing limitations, and so that might give you more of an out. But in general, you could argue that simply testing positive without any additional evidence of on-the-job impairment does not impact safety on the job and does not indicate that somebody is impaired on the job, and therefore that factor alone would not be, evidence of negligence on the employer's part. I think you'd have an argument like that available to you. Does marijuana use affect results of drug tests for other illegal drugs? Wow, Paul, I wish I were a chemistry expert and had the answer to that question, but I am a lawyer, not a doctor. I am a doctor of only jurisprudence, and so I do not know the answer to that. But my guess is that it probably does not, because the different drugs are metabolized so differently, but I don't know the answer to that one. Okay. And then there's okay. So I think that's all the substantive questions we have. Thank you all so much. These are terrific questions, and I will be sure that future iterations of this presentation incorporate some of these questions because they are really wonderful food for thought. Thank you very much, and please feel free to contact me if I can help you with anything else.
Thank you so much, Gina, and thank you guys again for joining us today. We had a couple questions about the upcoming webinars. They're on this slide in front of your screen. If you have any questions, please reach out to myself or Gina or Stephanie Hill, who sent the instructions earlier this week. We will be sending PowerPoint slides early next week and also CLE. Thank you so much for joining today. Have a great day.